come to order. Roll is open. Don't worry, you still get paid.
Mr. Chair, you have a quorum.
All right, first we've got Delegate Ward's bill, House Bill 2605, that largely is just a name change and codifying what the department has been doing for a number of years. I don't think that there's any opposition to that bill. Is anybody here in opposition? That bill is before us. It's been moved and seconded that the bill be reported.
Ayes 14, no 0.
That bill reports. Next, we've got Delegate Davis, House Bill 2127.
Yes, sir. Thank you, Mr. Chairman. House Bill 2127 was the one that you heard briefly before we suspended, which puts in when appropriate to assure frequent and continuing contact with each parent with regards to custody and visitation.
Didn't we address this last year?
So, sir, this is a little different. It's
a little bit farther than we went last year.
I would say that it addresses a different piece. It ensures.
I thought last year we scaled it back because we weren't comfortable with where you were trying to go, and my concern is that this is contrary to where we left off last year.
Well, so actually, we didn't try to go down this route last year. Last year, we went down the route of assuring that considering a joint custody was given the same weight as sole custody with either parent, and that's what we put in the code last year. This year, it just means that when the judge awards the time, that he takes into account the ability to have consistent, continuing contact with the parent.
Doesn't the judge already have that ability to consider that in deciding what's in the best interest of the child?
Yes, Mr. Chairman, he does, but this ensures that all judges take into account. The example I used was our law enforcement officers when they work a 3-day on, 4-day off schedule, that when the judge awards the hours and he goes to say the visitation shall be on these days, he recognizes that maybe this first responder works 3 days on and that visitation shouldn't be during those 3 days. But, Mr. Chairman, we've got peace in the valley on this one. I know there was a little bit of miscommunication.
Let's see whether we've got peace on the committee, because, we've spent a lot of time this year talking about taking away the discretion of judges, and judges clearly have a mandate right now to make decisions in this regard in the best interest of the child. Yeah. So let's, anybody here in opposition to the bill? Peace in the Valley. So
the Family
everybody,
Coalition
they support this bill. They want this bill.
I'd like to have them speak for themselves, Mr. Chairman, but they don't have opposition, and they don't think it causes a presumption.
Well, let's hear from them.
Okay.
Thank you, Mr. Chairman. I'm Dan Gray with the Family Law Coalition.
So you support this bill?
Initially,
you want this bill?
We opposed the bill on the House side. It was amended. There was a friendly amendment offered by the committee, and we, at that time, when it was on the House side in committee, we withdrew our opposition.
Mr. Chair.
Senator Deeds.
Mr. Chair, Mr. Gray, doesn't the court already have the ability to consider this and making a determination about custody and visitation?
In 2124.2.
Mr. Chair.
Senator Deeds.
Isn't this somewhat akin to answering the ultimate question? In fact, you can't ask a witness or an expert witness about the ultimate issue in contention, but you are basically building that into what the judge considers, aren't you?
Well, I think you already have that in there. In 2124.2.
So does this accomplish anything then?
We view it, we do not oppose it, we don't support it, we view it as a neutral because it merely restates what is already in the code in the preceding code section, if that makes sense.
That makes sense. All right, let's hear from anybody opposed to the bill? Anybody want to step up real briefly in support of the bill? Very briefly. We heard this bill last week.
Thank you, Mr. Chair, members of the committee. My name is Bretta Lewis. I'm a family law attorney and a guardian ad litem. I've been representing children in custody cases for close to 20 years. And if I may speak to the questions you were asking, the way that the words come out in 124.2, if you look at the subsection B, it has to do with custody. The 20.124.3 are the factors that have to be applied in circuit court as a matter of record, as well as juvenile court when determining the best interest. So from my perspective, advocating for children all the time, people really are looking at those factors, and making that language consistent between the two code sections, I think, helps those of us who practice, particularly when there are pro se parties, explain to them that we're applying it with custody and visitation, not just custody.
All right, thank you.
Thank you, sir.
Next. And we're not going to relitigate this bill, so I just need you to briefly make your point.
Fortunately, I'm not an attorney, so no
That-
litigation. Good morning, Mr. Chairman, committee
Congratulations.
members. Thank you. My name is Jennifer Cody. I'm a stepmom and a member of the NPO, as well as a graduate student in social work here at VCU. Research shows that even when factoring in parental disagreement, children who spend significant time with both of their parents benefit from lower levels of depression and anxiety, reduced incidence of substance abuse, better scholastic achievement, and better relationships with parents, step-parents, and grandparents. Unfortunately, some family courts in the Commonwealth continue to favor a model in which children spend most of their time with one parent while seeing the other less frequently, even when both parents are loving, competent, and engaged with their children. This outcome creates winners and losers, rather than fostering strong relationships between children and both of their parents. I strongly support this bill, which will work to ensure that the best interests of the child are considered when making custody decisions. The bill does not enforce a mandate or presumption or take any discretion away from judges. Instead, it encourages courts to acknowledge the compelling research that shows that time spent with both parents benefits children the most and should be pursued to the greatest extent possible. Thank you, and I respectfully ask for you to vote yes on this bill.
Thank you very much. All right, step right up. I didn't start the timer, but I am now.
And that's cumulative for everyone, right?
Yeah,
Okay.
that's it.
Good morning, Mr. Chairman and committee members. My name is Eddie. I'm a member of the National Parents Organization of Virginia, and more importantly, a loving dad. 63% of youth suicides, 90% of all homeless and runaway children, and 71% of all high school dropouts all come from single-parent homes. Our current system is failing us and our children. Please vote yes on HB 2127, which is backed by extensive research and would help prevent Virginia's children from becoming another one of these statistics. Thank you for your time.
Thank you. Yes, sir.
Morning, Mr. Chairman. Good morning, members of the committee. My name is Cole Bachenfeld. I'm a father and member of the National Parents Organization. We support this bill because it would emphasize in law what's already widely demonstrated by the studies, that children are better off when they have frequent and continuing contact with both of their parents, even when those parents don't live in the same home. This doesn't tie the judge's hands, doesn't limit their discretion. It'll still allow the court to adjust to each family's unique situation. It's a chance to make a positive difference for Virginia's children. Thank you, and I hope you support.
Good morning, Mr. Chairman and members of the committee. My name is Christian Posh, and I'm the Executive Committee Chair for the National Parents Organization of Virginia. For all the aforementioned reasons, I also support this bill and ask for your yes vote. And I do want to emphasize my colleagues, Bretta Lewis's comments earlier, that point out that, yes, last year we amended the .2 portion of the statute that deals with custody. But all it does is it requires the courts to consider joint custody. This year, we're amending the visitation portion of it. And everything we're hearing is that this is an important change that will absolutely improve the lives of Virginia's children without tying a judge's hands.
Thank you.
Thank you.
Senator McDougal.
Mr. Chairman, I understand what everybody's saying, but I would feel more comfortable if this was a factor instead of getting to this before the factor. So I'd move that we unstrike consider and move the new language to factor number 11.
Second. Family Law Coalition, have any view on that?
I think the coalition would be fine with that.
All right. That, you okay with that, Delegate? That may be your lifeline.
I appreciate the opportunity. I take it. I think it meets with the intent that everyone was trying to do, and I appreciate the opportunity.
All right.
Mr. Chairman,
Yes, Kristen.
in order to follow from the language, then it would say the court shall consider the following, and then we would have a new number 11 that would say you would consider frequent and continuing contact with each parent. Is
Mr.
that
Chairman.
okay?
Mr. Chairman,
Mr. Chairman, I think
Senator McDougal.
I think it probably needs to be 10, and number 10 needs to become the new 11.
Yes.
Actually.
Yes.
All right.
Mr. Chairman,
Senator
I
Edwards.
thought it would say, where appropriate, comma, assure frequent and continuing contact,
You
et
okay
cetera.
with that,
Yes.
Ryan?
Mm-hmm.
Okay.
Okay.
That's,
Where appropriate.
that's the motion. The motion to amend is before us. All in favor of that amendment signify by saying aye. Aye. All opposed, that amendment is adopted. The bill is before us as amended. Okay.
Ayes
Yes,
10,
sir.
noes 4.
Congratulations, Delegate.
Thank you,
Delegate
sir.
Aird. House Bill 2317.
Hi, good morning, Mr. Chairman and members of the committee.
Delegate, I think you've gotten the attention of Virginia's law enforcement community.
Yes, I think so.
All right, tell us about your bill.
Certainly. So House Bill 2317 comes at the request of a constituent of mine, Crystal Agner. Last year, Ms. Agner came to me with a very sad testimony about contacting law enforcement to be present during a custody exchange due to ongoing threats that had been taken place or made towards her from the participating party. When she contacted law enforcement, they declined to just be present or stand by while the exchange was taking place. And she'd asked the father of her child to have the custody exchange take place in the parking lot of their local law enforcement agency, which he declined to do, and he would only agree to do the exchange at a local nearby gas station. When she met him to meet up at the gas station, unfortunately, it ended very sadly with her husband, who was in attendance with her, being shot several times. So ultimately, she tried to do the right thing in having this concern because of the threats that were being made towards her, and just asking the law enforcement officer or agency to just be present while the exchange occurred. And so the bill before you would simply allow the courts the discernment as to whether to decide in a case where there is a history of familial abuse to have law enforcement present. In my eyes, I see this as no different than, for example, a lesser serious situation when an eviction occurs and law enforcement doesn't get involved. They try to just be present to keep the peace. And so ultimately, this language gives the court that discernment to consider whether or not to order their presence during a custody exchange.
Okay, Delegate, couple of concerns that have popped up, and the story you tell is very compelling, first of all, and I think all of us would agree that that a situation like that needs to be rectified, and it's most unfortunate. But first of all, I think that court can already order a transfer to take place someplace, wherever the court decides, like the police department, right?
It's my understanding that they do have that ability, but not, they can designate, it's my understanding, designate a designated location, but not the present, they have not the presence of law enforcement.
And I guess and I'll let the law enforcement community speak for themselves, but I guess what concerns some of us is that what we're doing is giving the courts this tool without really requiring any kind of coordination with the law enforcement, in which they can order law enforcement to be present at these exchanges. And it's not going to take very many of those orders before the resources of already stretched law enforcement agencies are stretched to the breaking point. And I think it would maybe help to hear from the sheriffs or state
Sure.
police or the chiefs.
Mr. Chairman,
Senator Reeves.
I just was going to caveat on your comment. When I was with Prince William, we had, it seemed like every weekend in the lobby, the duty officer was doing exchanges like that, and it seemed to work pretty good. But my fear is if we mandate this and then we have street officers getting pulled somewhere, and I don't know how they're going to juggle all that.
All right, let's hear from the sheriffs briefly.
Good morning, Mr. Chairman and members of the committee. We understand what the Delegate Ayer is trying to get to here. The problem we have with the bill, it doesn't say that the exchange will take place at a law enforcement agency. It can take place at homes all over the county. And as you say, it won't take very many of these before our resources are depleted for any given day. There's also a language issue, which talks about police stations. And in 86 counties, we don't have police stations. We have sheriff's offices. So it's going to be a resource
So
issue.
would you object to the bill if it said that at the request of either party, the court may order the exchange take place at the location of the agency?
It'd be a lot better if they have come into that. I'd have to run that.
I don't know whether it's necessary to do that.
I think they can do that already.
Right.
So there is a line that says, the order of the exchange can take place at an appropriate meeting place, including a police station, which could be generalized to state law enforcement agency or entity.
How about striking everything but at a police station?
Say that a different way.
The exchange may take place at may be ordered to take place at a police station.
Sure.
Kristen?
So I will also say,
Mr. Chairman,
Yes.
was the suggested amendment to say at the request of either party, in cases in which a history of family abuse has been considered pursuant to subdivision 9, the court may order that the exchange take place at a law enforcement agency or, not police station, I think, because.
you have sheriff's offices and
Sheriff's
police.
offices, right, so at the appropriate, I'll have to come up with the language, but I think you can include either a police station or a sheriff's office.
I think we're now generating some interest by the Supreme Court.
So I have a substitute drafted, number 3, for the clerk's reference. And this language, I believe, is a happy marriage between, and I'll let the Supreme Court speak, but I tried to marry.
Tell you what, while the substitute's being passed out, let's hear from Supreme Court.
Yeah. Let me make sure.
Mr. Chairman?
Make sure that's the right one.
They're not supposed to be. Huh? I think we ought to just pull the plug on this one. Okay. All right.
So she's talking about number 1.
So are we ready for this, or so we're going to suspend and take up another bill if we're not? We've got some serious time constraints. Tell you what, we're going to suspend and take up Delegate Campbell's bill.
She has number 1.
Delegate Campbell.
Just doesn't have a mention of
House Bill 1947. We talked about this bill last week, maybe in your absence. And I tried to give the delegate a little bit of an idea as to what some of the concerns that were articulated last week concerning his bill. As you recall, this involves mandatory minimum for somebody who calls in a bomb threat to a school. Questions were raised about why it affects only bomb threats, not fire threats or other threats, and the problems caused by disparity in treatment of somebody who's 17 versus somebody who's 18. Delegate, you want to briefly address the bill and some of those concerns I shared with you?
Sure, Mr. Chairman, members of the committee. This bill was a byproduct of a series of community meetings in my district in response to a rash of bomb threats that occurred at schools in our district. In fact, 32 separate threats over the course of about a 16-month period, resulting in thousands of hours of lost instruction, trauma to school teachers, administrators, children, and their families. And so the bill simply imposes a 5-day mandatory minimum for anyone making a bomb threat. The question as to why it would be applying to threats to burn, destroy, it just simply tracked the existing language in the statute is the reasons for that. I know there's questions about applicability to juveniles. As all the members of the committee are certainly aware, juvenile sentencing is a very complicated scheme in Virginia, and certainly mandatory minimums do not apply necessarily to a juvenile and a juvenile disposition. However, it would apply in the event that a juvenile was transferred and tried as an adult in circuit court. The mandatory minimum would apply in that instance. Okay. So with respect to disparate treatment of individuals, well, you know, we do that in all other areas of the code as well. Certainly, we've established the age majority at 18 in Virginia. The question of whether or not that's an appropriate age is probably a question that needs to be addressed for another day and another time as to whether or not the brain, adolescent brain, is sufficiently developed to be able to have criminal culpability at 18 years of age or not. But that's really not the issue here. The issue is ultimately we're trying to send a message that, you know, this will not be tolerated. Our General Assembly, the House, last year appointed a select committee and spent numerous resources and time addressing school security issues all over the state and brought back bills and recommendations, you know, and quite frankly, I think this is a byproduct of that as well.
All right. Anybody have any questions of the delegate? Senator Stanley.
Delegate, the way I read this, I mean, in subsection B, which you've added for the mandatory minimum, that would include, say, a juvenile who would be convicted of if they were under 15 years of age, a class 1 misdemeanor, but they'd still get a 5-day mandatory minimum?
I think that's what the statute says. I think ultimately the juvenile court judge would not be bound by that mandatory minimum under Miller v. Alabama and a progeny of other cases as well. I think that the mandatory minimum expressed by the legislature is certainly a factor for that sentencing judge to consider in making a disposition, but he's not bound necessarily with respect to that.
Mr. Chairman.
Senator Peterson.
Delegate, here's my question about this bill, and it's a mandatory minimum bill, which typically I vote against all of them. Especially with teenagers, especially dealing with school buildings. I mean, people say a lot of stupid stuff, and I've had 3 teenagers. I got another one right behind them. And how do we, I mean, one of the reasons why we give judicial discretion is so a judge can say, you know what, this was an isolated, stupid thing he said on Facebook or on Twitter, and I'm not going to put someone in jail for 5 days for one stupid mistake that didn't actually harm anybody. So, I mean, how do you justify, I know you want to, I understand the impact on your community, but how do we take that away from a judge that, again, we elect them to kind of make these decisions?
And I suppose you're talking with respect to a person 18 years of age or older at this point.
Well, I mean, high school seniors will be 18.
Correct.
A lot of them will be.
Yeah, I don't think you've completely deprived him of discretion. You're simply setting the baseline here. You're establishing that, you know, at least 5 days have to be served in some capacity or another. I don't think you're depriving him. It's a class 1 misdemeanor is punishable by up to 12 months in jail, obviously. What we're establishing here is a deterrence to that future activity, obviously. And I think when you balance the two, I understand, believe me, I'm a lawyer myself. I don't like having my hands tied in the courtroom either, quite frankly, but there's a time and place for everything. And when you have gone through 32 separate threats over the course of 16 months, something has to, to occur in order to deter that activity. And when
All
you
right. Delegate, do you have somebody here to speak for your bill?
No,
Or against
I
your
could-
bill,
I
or
could
to
just-
express concerns?
I'm not sure.
For it or against it? Against it? Step right up. Very briefly.
Mr. Chairman, members of the committee, Bonnie Atwood, the Virginia Fire Prevention Association. Our membership is mostly fire marshals, and of course, we agree with the goal to deter the false alarms, but we think that this language actually may do the opposite and make judges more reluctant to convict and defeat the purpose of the bill. So our organization is firmly opposed to it.
You think it will make judges less likely to convict people of pulling fire alarms?
Yes.
Okay. All right. I think we all get the issues, get the delegates' concern. Bill is before us.
Move. To pass it by indefinitely.
All right. There's a motion seconded to pass the bill by indefinitely. Any discussion? The roll is open. Well, Delegate?
Ayes 10, noes 4.
I'm sorry, but thank you.
I appreciate
Your
the
advocacy
committee's
was
consideration.
zealous. Delegate Aird, you want to step back up? I think I've seen your amendment, and I don't think it addresses my concerns.
Can
I
you
think-
repeat your concern for me?
I think it still is ambiguous with respect to the obligation it's placing on law enforcement.
And that's for
in that
amendment
it
number
says,
1?
"And may order that the exchange of the child take place in the presence of a designated third person."
Amendment number 1, I believe, says shall take place at an appropriate meeting place. And
may order that the exchange of the child shall take place in the presence of a designated third person. That second part is what I think is problematic.
So even if both parties identify a designated third party, you're saying that's,
Yeah, if they designate the sheriff, I think that the court would be ordering them to take place, ordering the sheriff to be present at the time the transfer takes place.
it's my understanding that the sheriff's department and the court are both amenable to this language. And so I think this is
It's helpful to know.
it's a happy medium to try and accomplish what is ultimately the goal of ensuring safety during these custody
Senator
exchanges.
McDougal.
Mr. Chairman, my question is, if the sheriff's not a party to this, I don't know that you can, I read this to say that the court can order that the transfer take place in front of the designated third party, but I don't think the designated third party is under control of the order. It is just the two parties. So whereas the previous language would have been ordering, it gave the court to order a specific entity, the sheriff or law enforcement, I think this is an order to the two parties. You have to do it at this location and in front of these people, and if those people aren't there, then the two parties are the ones that are in violation of court order, not the third party. That's,
Mr. Chairman?
Unless they take the order to the sheriff, and it's an order to the sheriff.
Mr. Chairman, I don't think this
Mr. Chairman?
gives them that authority.
Mr. Chairman?
Senator Edwards.
Yeah, I've seen this type of thing happen all the time. In Roanoke, they have a place called Sabrina's Place, which, among other things, I think is a place where they can exchange the children or have the children under supervised visitation. And it's true that somebody's not a party to the suit or under the jurisdiction of the court with regard to that particular case cannot be forced to do something. But my experience has been the parties agree. The children will be exchanged at a certain place and maybe with a person that who's agreeable to be involved. And as I say, I think there are some of these places throughout the Commonwealth in certain locations that have, like in Roanoke, Sabrina's
Safe
place is a good location
All
to
right.
do this type of thing.
A substitute has been distributed. Is there a motion on the substitute?
Move to report.
Move to report.
Move to report.
Well, you want to adopt?
Oh, yeah. Move to adopt the substitute.
All right, it's been moved and seconded the substitute be adopted. All in favor signify by saying aye.
Aye.
All opposed, the substitute is adopted. Is there a motion on the substitute?
I move to report it.
All right, it's been moved and seconded that the substitute be reported.
Ayes 8, no 6.
Substitute is reported.
I thank the committee.
Thank you. Next, we've got Delegate Collins. We've got a bunch of other delegates sitting here
I
for
think
some
they're all
reason.
waiting for rules.
Ah, okay. Delegate Collins, we got our other issues straight?
I think so.
Okay.
We'll get,
All right. We've got 1622. You know of any opposition to this bill?
no, sir, I'm not aware of any.
All right.
Would you like me to?
Charles, Steve, any concerns identified about this?
No concerns, Mr. Chairman.
All right. Anybody have any questions of the patron?
Yeah, Mr. Chair.
Yeah, Senator Peterson.
All right, what is this bill about?
So, Mr. Chairman.
I'm sorry, I thought you'd read it.
I read it, but I didn't understand it. Go ahead, you tell me.
Basically, Senator, what this is part and parcel to the human trafficking work that we've done. You might remember a few years ago, we allowed for hearsay testimony for 12 and younger. We have made it, we have gone across the board and made in-camera testimony in civil cases now 14. This is raising the age of 14 for in-camera testimony to match up with the criminal side of in-camera testimony for a 14-year-old. So that you might have a preliminary hearing and a protective order hearing at the same time. So we want to make sure that they don't have to come out and face their accuser. And that's basically all it's done, is just make it.
From 12 to 14.
Just
Move to
changes the
12.
age.
And now it's across the board, it's 14. We had a mismatch.
Anybody here in opposition to the bill? Senator, it's been moved and seconded the bill be reported. The roll is open.
Ayes 13, noes 1.
All right, that bill reports. Are those all the bills? All right, let me just say thank you to the members of the committee. Those are all the bills we've had. I also wanted to say we have a really outstanding staff, and our legal team has been outstanding. Whoever chairs this committee next year is going to be quite fortunate if we're able to hold on to the same team. Steve, Charles, Kristen, Hobie, thank you all so much for your work. We also have a work group that goes through each of these bills before they come to us, tries to scrub them, identify problems, and they've done a great job. So Mike Doucette sitting in the back of the room, Maria Jankowski, and others, thank you all for your assistance in that effort. So with that, thank you. And the committee will rise, I hope, for the last time. Yeah, we actually are going to do judicial interviews, and we'll have to certify, but that's it.